Well, inventive step. It's key to any patent case. And we do have to talk more and more about Europe.
We do, for the reason that with the UPC on the way, and the English judges paying increasing attention to the decisions of the Technical Board of Appeal at the European Patent Office, it's becoming increasingly important in the UK as well.
But is there really any difference between the two? I mean, problem and solution or windsurfer, does it make any difference?
I think there is a slight difference. Would you like to explain how the EPO deals with obviousness?
I'm a great fan of the problem and solution approach. It's structured, it's straightforward. You start off, what's the closest piece of prior art? And that's very easy. It's the one you have to make fewest changes for. Then, once you've got those differences, you ask, what differences do they make? What's the difference that the difference makes?
And then?
Then there's the clever bit, and that's formulating the technical problem. Bearing in mind that it makes some kind of difference, you then have to formulate it as a problem to be solved. And then finally, the question has to be, looking at all the other bits of prior art, is that an obvious technical solution to a technical problem?
Just before Lord Justice Jacob retired from the bench, he came up with a number of trenchant criticisms of the problem-solution approach, difficulties that it had in certain scenarios. Do you agree that they are really problems?
Well, with all due respect to Sir Robin, who's a far better patent lawyer than I am, I'm not sure. Some of his criticisms, I think, are criticisms for criticism's sake.
Would you agree that the hindsight problem is a problem?
Not so much. The key here is formulating the objective technical problem properly.
The problem and solution approach looks at the closest piece of prior art in formulating that technical approach. Is it not impossible not to have hindsight in that situation?
Well, how is that really different from the English court's approach? You're identifying the inventive concept, and you have to compare that with the closest piece of prior art, or the piece of prior art that you're considering at that time.
But under the English process, that takes place after one's identified the inventive concept, which is done merely by looking at the patent claims and the specification.
That's true, but I don't think it makes all that much difference. It's how you formulate that problem which is key.
So what about the second problem that Jacob identified, which is where it's not obvious as a problem? So in Haberman and Jackal, which was a case which involved a baby cup.
The Any Way Up cup.
Correct. That case, before that, all baby cups leaked, and the obvious, or the seemingly obvious, solution to that particular problem was to place a valve in the cup to stop it from leaking. However, the court found that not to be obvious.
I think there the key is the final step in the problem and solution approach, because that does ask, is it obvious? Now, objectively, you might say, oh, valves are known, it's obvious to put it in there. But the truth of the matter was, no one had done that, and it was a serious problem. And that really suggests that truly, for the person skilled in the art, it wasn't an obvious solution.
So then what about the final problem, which is the 5 1/4 inch plate problem? So, for example, if a 5 1/4 inch plate is invented, no such plate exists in the prior art, and so therefore, under the problem-solution approach, that 5 1/4 inch plate would not be obvious.
Again, I'm not quite sure that's true. It really fails much earlier in the problem-solution test in formulating an objective technical problem. If there's a difference between the prior art and the claimed invention, but there's no technical problem solved or technical problem addressed, it just fails at that level. There's no issue. It's not inventive.
So do you think, having considered all of those differences between the EPO approach and the English approach, do you think that the UPC will use the problem and solution approach or the English approach?
I think we're going to be outvoted here, given that problem and solution holds sway across Europe, Germany, Holland, France, Italy, everywhere else in Europe they use problem and solution, and we're out on a limb. I think the Unified Patents Court, when it comes into effect, is definitely going to adopt a problem and solution approach. What about you? What's your view?
I think you're probably correct. Very recently, Lord Justice Lewison approached this whole issue in Novartis and Medimune, and he said very trenchantly that the only question was a statutory question. Is it obvious?
And that's the same throughout Europe, isn't it?
It is. And so therefore, I think ultimately we will probably have to use the problem and solution approach.
Do you think that's a good thing?
I think harmonisation of European patent law is generally a good thing, so in this particular situation, I agree.
Thank you very much.